Imagine being lured to your death, your family staging a scene to make it look like self-defense. That's the chilling allegation in the case we're diving into today, as a prosecutor delivers a powerful closing argument, tearing apart every defense claim. Today, we're breaking down a high-stakes closing argument from the trial of Kevin Ellis, accused of the cold-blooded murder of his brother-in-law Matthew Rastelli, in American Fork, Utah on July 12, 2024. The prosecution alleges that Ellis, along with his sister and mother, orchestrated a deceptive plot to kill Matthew, staging the crime scene to feign self-defense. This clip captures the prosecutor's fiery appeal to the jury, where he dismantles the defense's narrative, pushing for a conviction on charges of murder and conspiracy.
Well, story time's over. Let's talk about the facts again. The murder of Matthew Rastelli was a needless tragedy. It was an unreasonable tragedy. There is overwhelming evidence that Matthew was lured to his death, and that the crime scene was staged with a knife planted in his hand. Even the defense admits this much. And during this trial, the defense has attempted to portray Kevin Ellis as a hero.
Here, the prosecutor immediately frames the central conflict of the trial. By acknowledging that even the defense admits part of the staging, he highlights the indisputable facts and pivots to attack the defense's interpretation of those facts. This is a classic prosecutorial strategy: concede minor points to gain credibility, then attack the core of the defense's theory. The defense attempted to paint Kevin Ellis as a hero, a white knight protecting his family, likely invoking self-defense. The prosecutor aims to directly refute this, establishing Ellis as the aggressor rather than a victim reacting to a threat.
That's the word they used during trial. And during their argument today, they said protector. They wanted to believe Kevin was a white knight rushing in to save the day. The truth is, Kevin was a cold-blooded murderer, lying in wait to kill his brother-in-law. And this dichotomy is what this case is about. The law does not require you to resolve every mystery connected to this case, or every question connected to this case. All the law requires you to do is answer whether Mr. Ellis is guilty of murder and conspiracy. Everything else is just noise.
This is a crucial moment where the prosecutor reminds the jury of their fundamental duty under the law. In Utah, like most jurisdictions, the jury's role is to apply the law as instructed by the judge to the facts presented. The charges here are murder under Utah Code AN 765203, which requires intent to cause the death of another, and conspiracy to commit murder, which would fall under Utah Code AN 764201. The prosecutor's noise comment is a rhetorical device to dismiss any red herrings or tangential arguments introduced by the defense that do not directly address the elements of these crimes, thereby refocusing the jury on the essential legal questions.
And that's what you heard during that argument. Noise. We need to separate the noise from the constitutional principles we all believe in. We need to separate the noise from the law that the judge has instructed you on. Separate the noise and focus on the evidence. Not what the defense counsel thinks, not what they're interested in finding out, not the information on the slides that was never introduced into evidence. Simply the evidence. So let's cut through that noise. Let's look at what the evidence tells us what happened. Now first, Kate told you what happened. She plainly testified that she and Tracy and Kevin conspired together to murder Matthew. We talked a lot about Kate and her incentives. You'll judge it. But note one thing that was very clear. When Kate truly believed something, she pushed back. She pushed back against Mr. Brown. She pushed back against Mr. Williams on 2 points. That she believed that what Matthew did to her was abuse.
The prosecutor is strategically using Kate's testimony to bolster the prosecution's narrative, even while acknowledging her potential biases. Kate, Matthew's wife and Kevin's sister, is a co-conspirator who has already pleaded guilty. Her credibility is undoubtedly a major factor for the jury. By highlighting instances where Kate pushed back on other points, the prosecutor is trying to show that when she testified about the conspiracy, she was telling the truth, and it wasn't simply a convenient narrative for her. This is an attempt to subtly rehabilitate a potentially compromised witness in the eyes of the jury, suggesting that her account of the conspiracy is the quiet truth, because it was corroborated elsewhere.
I think we could all agree at this point, she was not raped by Matthew. Asking your wife for sex, even when she doesn't want to, is not the same as forcing her to have sex. And she admitted as much, but she still saw it as abuse.
This is a delicate but important point in the prosecutor's argument regarding Kate's testimony. The defense likely tried to leverage Kate's perception of Matthew's behavior as abuse to create a justification for Kevin's actions, perhaps supporting a self-defense or defense of others argument. However, the prosecutor is drawing a sharp legal distinction. Consensual sex, even if unwanted by one party, is not the same as sexual assault or rape. By getting Kate to admit she was not forced, the prosecutor undermines any claim that Matthew posed an imminent physical threat that would legally justify deadly force under Utah's self-defense statute, Utah Code Ann 762402, which requires a reasonable belief that unlawful force is about to be used.
Testimony, everything else you hear, by what can be corroborated, what the independence confirms about what you heard. Corroboration is the quiet truth. So let's listen to what it has to tell us. The evidence. Two very different ideas. Kevin was a pawn, he was a dupe, he was a participant. We don't have evidence. We don't have evidence that he was a pawn. We have speculation, we have innuendo, but not evidence. We have evidence he was a participant. There's the tracking. He was tracking weeks before the murder. He was tracking the day of the murder.
This is where the prosecutor moves from discrediting the defense's theories to presenting affirmative evidence of Kevin's direct involvement in premeditation. Tracking Matthew weeks before and on the day of the murder demonstrates a clear pattern of surveillance and planning, which is highly indicative of premeditation, a key element for first-degree murder under Utah law. This direct evidence of active involvement contradicts the pawn narrative and strengthens the argument for Kevin being a knowing participant in the conspiracy and the murder itself.
You got that text? Warren, find mine. There was preparation. You babysat Kate's kids to make her lies more believable. Had to create that ruse that she went to the car rental company. No, everyone knew she had zero intent going back home with Matthew. The home was prepared. Toys were put away. The screen door was taken down. There was a blanket put on the couch. Two youngest children were kept away. A cardboard was put out front. Gate code was sent to Matt. The lights were turned out. Curtains were open. And look, Kevin was home for all of this. And you might reasonably believe one or two of these things Kevin didn't see or notice. All of them? No. Kevin knew preparations were being made.
The prosecutor is attacking the defense's attempt to compartmentalize Kevin's knowledge and involvement. By listing numerous preparations, babysitting, car rental, home staging, screen door removed, blanket on couch, kids away, gate code sent, lights out, curtains open, the prosecutor establishes a pattern of overt acts designed to facilitate Matthew's murder. Individually, some might seem innocuous, but collectively they paint a picture of a meticulously planned ambush. The argument is that for Kevin to be present for all of this, it's unreasonable to believe he was oblivious. This goes directly to establishing his knowledge and intent, crucial for both murder and conspiracy charges.
That's like what Kevin put on a gun and a holster. He knew. Then he waited in the front room for Matthew to arrive. He was part of the preparation. And there's the communications. Text messages with Kate. He'd rush back if Olaf came. He'd rush back to be there when Matt was there. There was deleted text messages by Tracy, to be clear. Why would she do that? Why the messages with Kevin? because she knew there was incriminating evidence there, and you can draw that inference too.
The deletion of text messages by Tracy, Kevin's mother, is presented as powerful circumstantial evidence of a guilty conscience and an attempt to cover up the crime. Under the federal rules of evidence, and similar state rules like Utah's, attempts to conceal or destroy evidence can be admitted to show consciousness of guilt. The prosecutor is explicitly inviting the jury to draw an inference, a logical conclusion based on the evidence. The inference here is that Tracy deleted messages with Kevin because they contained incriminating evidence, linking Kevin directly to the conspiracy and premeditation.
There was the lunch, then that post-lunch discussion with Kate and Tracy. Or was over, think about the situation. Kate and her kids, and Tracy and a couple of her kids, and Kevin are all living in the same home. They didn't need to put into text messages, into phone calls, what they needed to put to Tara Lynn living out of state, or Rachel living far north of here. They just talked about it. You can draw that conclusion that by living together, they could just talk down the hallway to each other. They communicated in advance of this murder. There was the cover-up. There was the planting of the knife that everyone agrees happened. There was the statement to be careful. Careful, because Matt might still be kicking.
This segment introduces two critical pieces of evidence further undermining the self-defense claim. First, the planting of the knife is direct evidence of a staged crime scene, designed to create a false narrative of self-defense. This directly refutes the reasonableness element required for self-defense under Utah Code AN 762402. Second, the chilling statement, "Be careful, 'cause Matt might still be kicking," indicates a cold, calculated mindset, completely at odds with someone acting in a panicked, defensive manner. It speaks to malice aforethought and specific intent to kill, rather than a proportional response to an immediate threat.
The statement that he told the police that that guy had a knife. That he was afraid for his life, so he shot. Not afraid for Kate, that's not what he said. Not afraid for Tracy or the home, that's not what he said. He was afraid for his life, so he shot. And shoot he did. 7 times, 3 times in the back. No
The prosecutor is directly challenging the credibility of Kevin's self-defense claim by dissecting his own statements and actions. If Kevin genuinely feared for his own life as he claimed, it directly contradicts the idea of him being a protector for others, which the defense tried to establish. More damning, shooting Matthews 7 times, 3 times in the back, while there's no evidence of any struggle, powerfully undermines the core elements of self-defense, particularly the reasonableness and proportionality of force used. In Utah, force must be proportional to the perceived threat. Firing multiple shots, especially into the back, suggests an intent to kill, not merely to neutralize a threat.
It's worse for Mr. Ellis than what the state has said. Under the state's theory,
This is a tactical move by the prosecutor, arguing that even the defense's own version of events is detrimental to their client. If Matthew had time to walk around, take his shoes off, and then be shot, it further negates any claim of imminent danger or surprise, which are crucial for a valid self-defense argument. Under Utah Code AN 762402, the belief of imminent danger must be reasonable. An extended timeline, without any evidence of agitation or a weapon from Matthew, makes Kevin's actions appear less like self-preservation and more like cold-blooded execution.
he could have at least claimed, or the argument could have been made, I should say, that he was surprised. But if it was a minute and a half, where Matt walks around, takes his shoes off, he knows who it is. He's not surprised. He doesn't need to shoot, because again, no evidence of agitation, no actual evidence of struggle, no actual evidence of an argument, no evidence Matt had a knife. Even under the expanded timeline, he should have never shot Matthew. Altogether, the direct evidence, the circumstantial evidence, and the inferences you can draw show that Kevin was not a pawn. He was a knowing, voluntary, full-throated participant in this conspiracy. Now, in contrast, this direct and circumstantial evidence was that noise I spoke about, the speculation, the innuendo, the incorrect interpretations of the facts. Trials are about whether a defendant committed a crime, not whether the investigation was perfect, and it's not about whether someone else was involved. You are not here to pass judgment on Kate, Tracy, on Rachel, on Tara Lynn, Detective Nordine, Patrick Serpoli, or any other aspect of the investigation. Only Kevin.
The prosecutor again refocuses the jury on their singular task, determining Kevin Ellis's guilt or innocence. Defense attorneys often try to introduce reasonable doubt by pointing out flaws in the police investigation or by highlighting the culpability of other parties. While a jury can consider investigatory flaws if they create reasonable doubt, the prosecutor here is arguing that minor imperfections in the investigation don't negate the overwhelming evidence against Ellis. This is a direct counter to the defense's attempt to distract from Kevin's actions by shifting blame or criticizing the investigative process.
And whether the evidence adduced proves him guilty or not. Was the police investigation perfect? No, it was not. And of course not. Common sense tells you there's always one more thing that you could do. Always one more thing 18 months down the road that in retrospect, yeah, maybe I could have done that. The important part is whether the investigation that was done produced sufficient evidence. And here it produced volumes of evidence against Mr. Ellis and his co-conspirators. Enough evidence to prove Kevin guilty beyond a reasonable doubt. There's a saying, if ifs and buts were candy and nuts, then every day would be Christmas. And that's the defense argument. There's lots of ifs and there's lots of buts. But that's not the world we live in. It's not Christmas every day for them. I don't want you to ignore something you might find important. But I want you to keep in mind the actual standard. And that is, given the evidence you have, are you firmly convinced? And in the end, there is no evidence that Kevin had any basis to believe he or anyone else was in imminent harm that night. The standard in the law the judge gave you. And there is no evidence that Kevin acted reasonably under the circumstances. Again, the word in the law the judge gave you. The evidence we have disproves self-defense. It disproves the idea, the speculation that Kevin acted reasonably. There is absolutely nothing in the laws of the state of Utah that allows you to hit a line of cocaine, put on a holster, grab a gun, let your sister lure someone into a home, lie in wait in a darkened room, and then shoot your brother-in-law moments after he walks in the door. That is murder. That is not self-defense.
This is the climax of the prosecutor's argument against self-defense. He explicitly states that Kevin's actions, cocaine use, arming himself, luring Matthew, lying in wait and then shooting, directly contradict the legal requirements for self-defense under Utah Code Ann 762402. The prosecutor is arguing that these actions demonstrate clear premeditation and malice of forethought, which are the hallmarks of murder, specifically first-degree murder in Utah. The cocaine use in particular could undermine any claim of reasonable belief of danger, as intoxication can impair judgment. This powerful statement underscores that Kevin was not reacting to an immediate threat, but was executing a plan.
There is nothing in the evidence that provides any basis to support either perfect self-defense or imperfect self-defense. And you do not need to willfully blind yourself to the evidence or legitimate inferences because of those ifs and because of those buts. When you apply the common sense to the evidence, your answer should be clear. Kevin was an integral part of the conspiracy. He was the trigger man. He was the one who completed the conspiracy. Kevin murdered Matthew, and the evidence disproves speculative self-defense claims. Now, before I end, just want to point out two more things. One is about the jury instructions. Instruction 47 talks about the imminency and reasonable requirements for perfect self-defense. And instruction 55 talks about the reasonableness requirements for imperfect self-defense. And Kevin Ellis did not have any imminent danger that he was facing. You're supposed to consider factors like the nature of the danger, the immediacy, the probability that there was unlawful force coming at him, whether Matthew was violent, patterns of violence, and other relevant factors. We've gone over the evidence numerous times. I don't need to tell you this, but the evidence shows there was no imminency that Kevin was responding to. He was not under a reasonable belief that he needed to shoot Matthew. There's nothing in the evidence to indicate any form of reasonableness.
The prosecutor hones in on the critical legal element of reasonableness for both perfect and imperfect self-defense, as likely outlined in Jury Instructions 47 and 55. For perfect self-defense, a person must reasonably believe that unlawful force is about to be used against them, and that the force used is necessary. Imperfect self-defense, where a defendant genuinely but unreasonably believes deadly force is necessary, might reduce a murder charge to manslaughter. However, the prosecutor argues there's no evidence of reasonableness, dismissing both forms of self-defense and firmly pushing for a murder conviction.
The second point I wanted to make to you was about reasonable doubt. Again, I've called this noise from the defense argument speculative, because it's not based in the evidence. It's based in maybes. During this whole trial, you didn't hear a single witness testify that anyone told Kevin Matt was dangerous, or that he had a knife, or that he was coming to rape Kate or commit any other crime or imminent harm. You haven't seen a single text message.
The prosecutor concludes by emphasizing Kevin's choice in the existence of alternatives to deadly force. This directly counters any self-defense claim. If a peaceful option, or calling the police, was available, using deadly force becomes unreasonable. The statement Kevin was the danger to Matt, is a powerful inversion of the self-defense narrative, asserting that Kevin was the perpetrator, not the protector. This final appeal urges the jury to find Kevin guilty based on his deliberate and unlawful choices. In a significant turn of events, a Utah jury delivered its verdict for Kevin Ellis on January 29, 2026. After deliberating for hours, the jury found Kevin Ellis guilty of murder in the shooting death of his brother-in-law Matthew Rastelli, unequivocally rejecting his claims of self-defense. He was also convicted of obstruction of justice, 2 counts of domestic violence in the presence of a child, possession of a gun as a restricted person, and drug possession. However, the jury delivered a surprising split verdict, finding Ellis not guilty of conspiracy to commit murder, suggesting they were not convinced he knowingly conspired with his mother and sister to kill Matthew. Kevin Ellis faces life in prison for the murder conviction, with his sentencing scheduled for March 23rd. This case, revealing a dark family drama, continues to unfold, as his mother, Tracy Grist, still awaits her own murder trial in April.